All right, what do we got?
Fiona Strachan on Facebook. If an I-130 gets denied and your I-485 didn't get denied, you went to your green card interview and they said they would open back your I-130, but you haven't heard anything from immigration. Then the lawyer that messed the case up did the reopening and it got dismissed. What's the next step?
Refile again because your case is denied.
Okay, Sajaka Jaka on YouTube. For an employment-based I-485 application, if I received an RFE due to late registration of my birth certificate, what supporting documents should I submit as further evidence or proof?
It's late registration. Who are you trying to prove? You're trying to prove who is who. You're trying to prove you're yourself, or you're trying to prove that one of your parents is your parent? What was the question?
It's for late employment based I-485 application. They received the RFE due to late registration for the birth certificate. So now they need supporting documents to submit for further evidence.
Affidavit. Well, you got to prove you are who you are. So affidavits from friends and family that you are who you are. It's an employment-based case. So you just got to prove your own identity. School records, medical records, hospital birth records, that type of thing.
Okay, Nigel, email. My mom wants to file for me. I'm 52 years old, but she tried doing it for me 6 years ago. We were told I would need to leave the U.S. and be banned. Should we try again or wait for Biden to roll out the amnesty plan?
You should speak to a lawyer and figure out why you need to leave the U.S. Maybe you need a provisional waiver. It sounds like that's what you need. I would start with a provisional waiver because who knows if Biden will pass the law. And if he does, you could always switch it over. But based on reading between the lines, sounds like you need a provisional waiver.
Jennifer Reeves on YouTube. What does it mean if my 485 is under pending review?
It means they're reviewing it. Two more, Yo-Yo.
All right. It's Apple Pie on Facebook.
Right.
How do you calculate CPS age for a derivative? What must be done so a person doesn't age out?
Well, generally what it is you get to add the time it took the I-130 to get approved to the child's 21st birthday. I mean, there's different cases, but the most general one, because Child Status Protection Act could be you filed by your permanent residence parent and they became a citizen before you were 21. It could be you're a derivative on an employment case or on an F2B case. Let's take that because that's the most basic one. Let's say you are a derivative child on a preference category case. That could be an F2B, an F1, an F3, an F4, an employment-based case. Doesn't really matter. You get to add the time it took either the I-140 visa petition or the I-130 visa petition onto the child's 21st birthday. Let's say it takes 2 years for the I-130 to get approved. Now the child has till 23 to get a green card. That child's birth date or age will be frozen at the moment that child pays the visa fees at the National Visa Center, provided he or she does within that 2-year period up to the 23rd birthday in this particular example, and as long as those fees are paid and priority dates are current, and they pay those fees within 1 year of the priority date being current, or files the adjustment same way. It's complicated. I may have made it more complicated for you, but that's basically it.
Okay, and last one for tonight. Mel, she's royal on YouTube. I'm undocumented, got married in 2018, got my I-130 approved in October 2020. Now I'm filing for VAWA. What forms do I need for 601A, 601 and I-485 or all?
You don't need a 601A. A 601A is for a provisional waiver. So if you're filing a VAWA, no matter how you enter the United States, you're eligible to adjust. So file an I-485 and the I-360 VAWA. Thanks for watching. For more Bradshaw Live, like and subscribe to our YouTube channel.